Hello, I'm Jesse Curtis. I'm a staff instructor here at the Wyoming Law Enforcement Academy. We're going to spend the next several minutes discussing Wyoming criminal law procedures. I'd like to begin with a short video that talks about the debate on the relevance of rules.
As per in the code, an act of war, and this be exactly that, can only be declared by the pirate king.
You made that up.
Did I now? I call on Captain Teague, keeper of the code.
Srisumbaji proclaimed this all to be folly. Hang the code! Who cares about...
Code is the law.
What rules are and their focus is not a new debate. Whether they're hard and fast and immovable or flexible guidelines that we use in our jobs. As law enforcement professionals, we have a lot of guidance on how to do what we do. The first concept that I want to talk about is the foundation of what we do. Answers to this question are typically we protect and serve, that we enforce laws, or various other tasks that we do. But we have a very unique foundational authority that is unlike anyone else in our citizenry, and that authority is to seize. We seize people and we seize things, and it's fundamental to what we do. Indeed, if we could become masters at use of force, which is the seizure of people, and search and seizure, then we are well on our way as law enforcement officers. When we're talking about seizing, we have a lot of guidance as to how and when we seize, where we seize, and even why. And a lot of this is covered in procedures. For instance, when we seize is covered by procedures, and we'll discuss that today. Where we seize, where we have the authority to seize, is also covered in procedures. How we seize depends on what it is. If we're seizing people, then that is covered through use of force. If we're seizing things, much of that is also covered in procedures. And finally, why we seize things is what we typically think of as the law, but it's actually our statutes themselves. So as you can see, procedures are very important. We don't get this from just one source, but from many. And we'll begin with the U.S. Constitution. In the U.S. Constitution, there are several amendments that discuss how we do our jobs. The Fourth Amendment, the Fifth Amendment, the Sixth, the Eighth, and the 14th all give us rules on how we are to operate. The Fourth Amendment, for instance, we discuss search and seizure, and you'll also find use of force in there. In the Fifth Amendment, we talk about due process, double jeopardy, and protection against self-incrimination. The Sixth Amendment is all about the trial process. The Eighth Amendment, we talk about protection from cruel and unusual punishment, and typically applies to the convicted people. And under the 14th, we have due process as well as equal protection. So we have in our U.S. Constitution a lot of guidelines for how we protect people, how we do our jobs. The next layer is found in Wyoming Rules of Criminal Procedure. This is something that's relatively unknown to most law enforcement officers. It's considered a lawyer's book. However, it has a lot of guidance for us. For instance, how we charge an individual, and this is the logistics of how we charge. What are to be in the charging documents, what the warrants are to look like, how they're to be served, when they're to be served, things like this. We have some more rules regarding the court process, preliminary hearings all the way through judgment and sentence, and what those processes are to look like. Evidence, and this is where we come in directly as officers again. Suppression hearings and what they're comprised of and what their function is. Depositions, and then Rule 41, which is very important to us, and that is our search and seizure, how we are to search and how we are to seize things. The next layer that we're going to talk about is the Wyoming statutes themselves, particularly Title VII. In Title VII, there's a lot of information for us on what we are to do. Our foundational arrest authority itself, jurisdictional limitations, where we can exercise that authority. They also discuss grand juries, state grand juries, search warrants. The trial, appeal, and sentence are all articulated in Title VII of our Wyoming state statutes. So we have several layers of how we get our job done. And it provides us guidance on how do we do our day-to-day tasks. And they're far different from the criminal statutes that we typically think of when we're enforcing the law. This is actually kind of a model, if you will, on how to do our jobs. Next, we'll go through some definitions that we'll need for the rest of the course. We'll talk about private law, public law, substantive law, procedural law, crime, and tort. In all of these, there will be two definitions. One, the first being the legal definition, and the next more of an application or a working definition. Private law, according to Black's Law Dictionary, as used in contradistinction to public law, the term means all that part of the law which is administered between citizen and citizen, or which is concerned with the definition, regulation, and enforcement of rights in cases where both the person in whom the right inheres and the person upon whom the obligation is incident are private individuals. So what does that mean for us as officers? Private law is a person who has an issue with another person. And an example of that, a very common example of that, would be a breach of contract. So the government's role, as it applies to private law, is indirect. The people do not have an issue with the government. Rather, the people have an issue with each other, and the government literally acts like a referee. They provide the venue, they provide the rules, so that the two individuals can come to an agreement in a civil manner. And it is important in our system of government that we have such a process in place. Places today that do not have this resort to all kinds of violent actions. And even in our history, you can think of range wars, water wars, things like this, where people did not take the process but took it into their own hands, and bad things happen. So this is what private law is. One person having an issue with another person, and the government has an indirect interest in that. The next definition is public law. The laws that cover administration, constitution, and criminal acts. It controls the actions between the citizens of the state and the state itself. It deals with the government's operation and structure. A more common application of that is the idea that a person who has an issue with the government, or more precisely, the government has an issue with that person. This is what we think about when we talk about criminal statutes. In distinction with the private law, public law is always defined by crimes. This is something that has occurred that is not only causing an injury to an individual or an individual's property, but also is considered by our society as harmful, if you will, to the public itself, and therefore it has a punishment of some sort. The next definition is substantive law. It states that part of the law which the courts are established to administer, as opposed to the rules according to which the substantive law itself is administered. That part of the law which creates, defines, and regulates rights, as opposed to the objective or remedial law, which provides the method of enforcing rights or obtaining redress for their invasion. Substantive law, in a nutshell, is a society's attempt to define what justice is, and that is our criminal statutes. What is right and wrong? How do we get there? And that is very different, and you can look at that on a national scale and compare it to other countries in the world, and what we define as right and wrong in some instances is far different than what other nations consider right and wrong. Even here in Wyoming, we have a neighbor to the south who considers things very differently than we do when it comes to the legalization of marijuana. Their society has determined that marijuana is right, it's legal to use, whereas in Wyoming, we take an opposing stance. If you want to reverse that on another issue, typically we talk about gun laws. We take a much looser stance on the regulation of firearms in Wyoming than they do in Colorado. So not only at the national level do you find substantive law that's different, but also at the state level, and even in certain cases at the municipal level, you'll find different cities and towns that have particular laws for their societies. But it is our attempt to figure out what justice is, what is right and what is wrong. Procedural law is the next one. The technical aspects of a legal system that states the steps that need to be followed while enforcing criminal or civil law. So this is not the statutes themselves. This is how we get there. In other words, this is a society's attempt to define how justice is served. And this goes back throughout our history. Our founders, when they came over, had a good, healthy fear of government, and that has carried through our system today. And how we get there is important. We are very unique, I believe, in this country in how we serve justice. The benefit of the doubt is always given to the defendant, not the government, and that is unique in our world. The next definition is crime. A crime is an act committed or omitted in violation of public law, either forbidding or commanding it, a breach or violation of some public right or duty due to a whole community considered as a community in its social aggregate capacity, as distinguished from a civil injury. In application, a crime is an act or omission with some sort of injury to the public welfare with a prescribed penalty. And the implication there is that it's a violation of statute. The next one is tort. A tort is a legal wrong committed upon the person or property independent of contract. It may be either 1, a direct violation, invasion of some legal right of the individual, 2, the infraction of some public duty by which special damage accrues to the individual, 3, the violation of some private obligation by which like damage accrues to the individual. In the former case, no special damage is necessary to entitle the party to recover. In the 2 latter cases, such damage is necessary. So a tort, in its application, is some sort of duty that's owed to another. That duty is breached, harm was caused of some sort, and the breach was the proximate cause of harm. So this can be between individual and individual. This can be between the government and an individual. But some duty was owed to someone, and because of our inability to fulfill that duty, harm was caused, and we are the cause of that harm. That is a tort. We must understand that we've all taken an oath to defend documents. It is interesting to note that we have not taken an oath to protect people, to serve people, or even in most cases to enforce the law, but rather we have taken an oath to support and defend literally documents and the principles underneath those documents. And those are the United States Constitution, Wyoming State Constitution, Wyoming State statutes, and for some municipalities, the laws of that town or city. Why do we do this? Why is it important that we swear an oath to defend the principles of a document as opposed to people? Well, it's quite simple. Our founders, like I said earlier, had a very good, healthy respect and fear for government, and they understood the capacity of government to become more than it was intended to be, and to turn into, quite frankly, an ugly monster. If you look at these documents, they do give the government, and we as actors of the government, our authority to take away liberties of the citizenry. But at the same time, it also puts restraints on government and therefore on us as to what those authorities are and when we can use them. It's very important for us as officers, I believe, to understand those restraints and understand that we must, at all costs, abide by these documents and their principles. Otherwise, quite frankly, we become the very monsters that we are trying to catch. Our society really does depend on us defending these documents and therefore them very well. In this next video, I will show you an example of at least a perception of how that trust is violated.
In Seattle, a sheriff's deputy has pleaded not guilty to charges he assaulted a 15-year-old girl last fall. Prosecutors have released a surveillance video of the alleged assault. A warning, the pictures you're about to see are disturbing. The video shows 2 King County Sheriff's deputies escorting 15-year-old Malika Calhoun to a holding cell. When Deputy Paul Sheen asked the girl to remove her shoes, she's seen slipping out of her left shoe and kicking it at him. Sheen rushes into the cell, kicks the teen, and pushes her against a corner wall before flinging her to the floor by her hair. He then squats down on Calhoun and hits her twice. Deputies say the girl was, quote, real lippy, and that she had called them, quote, fat pigs. Paramedics were called after Calhoun had complained that she had difficulty breathing, but she did not require hospitalization. Calhoun and another 15-year-old girl were arrested after they were found in the other girl's mother's car, which had been reported stolen.
And that concludes this module.